Members, it's the appointed time, and there is a quorum. So shall we invite the administration team to join us?
Cục 各位早晨
，Good morning. This is a public hearing on Audit Report number 7, and this is about Chapter 8 on Sha-Tin section of Route 8. And I'd like to thank the Secretary and your team for coming. I will not introduce you one by one. Before I start, I would like to call upon the Director of Audit to brief us on Chapter 8 of Report number 70 so that we can have a better understanding of the situation. Director of Audit, please. Chairman, thank you for inviting me to brief you on Chapter 8 of Audit Report number 8, and that is on Sha-Tin section of Route 8. There are 4 parts. The first part is the introduction, that is the background to the audit review. Now, Route 8 connects Sha-Tin and North Lantau, and it passes through Changsha Wan and Qingyi. It is 27.7 kilometers long and is made up of 3 sections: North Lantau, Qingyi, and Sha-Tin sections. And this is to ease the traffic congestion of roads connecting between Kowloon and Sha-Tin, and in order to meet with future transport needs. The government started the construction of Sha-Tin section in 2002. This section connects Sha-Tin and Changsha Wan, and the works is implemented through 3 contracts, and that is Contract A, B, and 3 referred to in the audit report, and 1 traffic control and surveillance system contract, and that is Contract D. Now, contracts A, B, and D were implemented by the Highways Department, and Contract C was implemented by the CEDD. The design and construction supervision of Sha-Tin section were conducted under Consultancy X for Contracts A and B by Consultant X, and Consultancy Y for Contract C by Consultant Y. The Finance Committee of Electrical allocated a funding of $7.0 billion to for the investigation, detailed design, and construction of Sha-Tin section. After the major works have been completed, the Sha-Tin section was commissioned in March 2008. As of December 2017, the government had spent $6.18 billion on Sha-Tin section. The expenditure of the 4 sections were $1 billion above the original estimate. The Sha-Tin section cost $900 million less, or 13% less than the allocation of the FC. Now, the Audit Commission carried out an audit review of Sha-Tin section, including contracts A and C. As for the TCS system between Sha-Tin and Qingyi, contract D, that was covered by an audit review of Qingyi section in 2014. The second part is about Contract A managed by the Highways Department. Contract A covers the construction of a 1.9 kilometers 3-lane dual-lane Lai Chi Kok viaduct from Lai Wan Interchange and Butterfly Valley, and also a carriageway in Butterfly Valley. The Highways Department awarded Contract A to Contractor A in September 2003, and the contract amount is $1.07 billion. The contract period is 49 months, and the works was completed in November 2009, 24 months later than you scheduled, and the contract amount, including variations, was $1.445 billion. Now, Contract A and Consultancy X, there were disputes, and dispute on Contract A involved two major issues: adequacy for the design for viaduct structure and erection, and then measurements and valuations of additional or varied works. And most of the disputes have to do with the design of the viaduct. As for the dispute on Consultancy X, it involves mainly the design of the viaduct. Ultimately, based on a no admission of liability, the government agreed to pay $273 million to Contractor A, and Consultant X agreed to pay the government $133 million to resolve the disputes. In our audit review, we found that in the course of settling the disputes, and after considering the views of the legal experts and the engineering expert, Highways Department thought that the design came up with by Consultancy X has not taken into account the temporary loadings during construction. And then tender query, the temporary loading question was raised, but its answer was misleading people to think that its design has already taken into account the construction and erection loadings. So we suggest that the Highways Department, in taking forward projects in future, must adopt measures to strengthen vetting of consultants' design, including asking or reminding consultants to give clear and accurate reply. The third part is about Contract B, managed by Highways Department, and Contract C, managed by CEDD. Contract B covers the construction of a 2.1 kilometers 203-lane east Eagle's Nest Tunnel. And the Highways Department awarded Contract B to the contractor in September 2003. Contract amount $1.836 billion. Contract period 49 months. And the works were constructed in February 2009, 15 months later than the original schedule. And the total expenditure of contract, including variations in pricing, is $2.317 million. In our audit review, we observed that in Contract B, there was a discrepancy between a contract clause and a contract drawing, and the contract clause in relation to measurement of tunneling works were not clear, and as a result, there was an omission in the bills of quantities. And ultimately, the Highways Department had to pay Contractor B $98.3 million. Therefore, we suggest that the Highway Department, in preparing contract works document, must adopt measures to strengthen the checking on contract clauses and contract drawings to make sure that they are consistent, and the contract clauses should be further vetted in relation to measurement. Now, Contract C covers the construction of a 1.6 kilometers dual 3-lane Sha Tin Heights tunnel and a tideway approach roads. The CEDD awarded the contract to Contractor C in November 2002, and the contract amount is $1.074 billion. Contract period 54 months, and the works were completed in September 2008, and the contract amount, including pricing adjustments, was $1.2 billion. In our audit review, we observed that the CEDD committed a processing error in drafting contract C, and as a result, the contractor C in supporting the facilitation work in the site had a facilitation period of 7.5 months instead of the agreed 9 months. So we suggest that the department in preparing time program for different contractors should make sure that the information is correct. The fourth part is about the usage management of shut-in section. Now, one of the reasons for building this section is to ease the traffic between Kowloon and Sha Tin, especially the traffic congestion in Lions Rock Tunnel and Tate's Car Tunnel. According to TD's information, as of April 2017, during the peak hours during the working days, the Eagle's Nest Tunnel and the Sha Tin Heights Tunnel in Sha Tin have still a spare capacity, but then for Lions Rock Tunnel and Tate's Car Tunnel, the traffic has exceeded the design capacity, so we suggest that the Transport Department should explore measures to further use the residual capacity of the Sha Tin section of Route 8 so that the congestion between Kowloon and Sha Tin can be eased. The Route 8 Sha Tin section and Cheung section make up Cheung control area. After the Sha Tin section is commissioned, the TD has, through open tender, outsourced the management, operation, maintenance of Cheung control area to a contractor, and the contractors or the operator's performance was monitored by TD, EMSD, and HSD based on their respective work portfolios. In our audit review, since the present contract started to take effect in September 2013, the operator could not provide the manpower level as required, and the problem is particularly serious with EMS staff. And as of December 2017, administrative and support staff and building maintenance staff have not been monitored in terms of their level since the contract took effect. So we suggest that the TD and the relevant department should adopt measures to ensure that the operator will follow the relevant requirements on manpower level and also effectively monitor the operator's performance. And our recommendations have been agreed upon by the relevant departments. I would like to thank the department staff for their full cooperation during the audit review and for their help and response. Thank you, Director, for your briefing. Now we would like to call upon Mr. Frank Chan, the Secretary for Transport and Housing, to speak, and the speeches are with us. Please. Chairman, I would like to first thank the Audit Commission for carrying out audit review on the highways departments and CDDs in their duties in management of the contracts for Sha Tin section of Route 8 and also for Transport Department in their using and management of the tunnels. And they have provided us with valuable opinion, and I would like to thank the PAC for giving us an opportunity to explain to give you all the details. Overall speaking, we accept the various recommendations made in the report, and we are actively supervising the various departments to do appropriate follow-up work. The THP has all along been supporting the work of the various works department on the policy level, and the Bureau has been liaising closely with the various government departments, and including the Highways Department, and we try to understand and monitor the progress of works of Sha Tin section of Route 8, and if necessary, we would give guidelines to the project to ensure that the project was completed smoothly and in line with the relevant policies and procedures. Now, after the commissioning of the tunnel, the THB and the TD has been monitoring the usage of the situation, and the TD is responsible for monitoring the operator of the Changsha control area, and appropriate measures will be put in place to improve the traffic condition and enhance the operator's performance. Now, on the various recommendations of the report, I have asked the relevant departments to take a serious review and implement improvement measures. Now, in terms of management of contracts, the report suggests that in terms of vetting project design and dealing with tender query, they should comply strictly with the relevant guidelines and regulations. In fact, in August 2006 and May 2013, the Highways Department has revised the design manual on roads and railway structure, and this sets out the requirement that professionals and professional teams should carry out independent checking on consultants and contractors in relation to design of the roads. And also the works departments has set up a working group to review the project handbook, administration handbook, and after the review has been completed, the working group will strengthen the guidelines on handling tender query. And the Highways Department, in accordance with the Project Administration Handbook, will deal with tender queries and strictly abide by the requirements that will be incorporated into the handbook. At the same time, the Highways Department will extend the coverage of the present vetting mechanism on tender documents to cover the responding to tender query, so that we will also be strengthening the relevant guidelines so that we can minimize the adverse impact brought about by incorrectly responding to tender query. And the report also suggests that in preparing documents for contracts, we should strengthen our work, including examining more carefully the contract clauses, drawings, bills of quantities, and other interface projects. In fact, the CEDD in October 2010 revised the Project Administration Handbook, and it sets out that wherever possible, there should not be any items to be omitted, and there should be a review or scrutiny of the bills of quantity. Now, in response to the report's recommendations, the Highways Department will ask its staff and consultant to conduct an independent review on the BQ. And also, as mentioned, there was a working group which is now looking at the relevant guidelines under the Project Administration Handbook, and where we find that there are related projects in preparing the contract documents. The timetable of the relevant projects should also be taken into account to minimize the conflict among different contracts. And in future, when the Highways Department prepares the tender documents, will abide by the relevant requirements in handbook and will carefully assess and look at whether all the interrelated projects have consistent timetables. As for the usage of the shortened section of Route 8, the TD has, in relation to the 3 crossover tunnels and the 3 land roads connecting Kowloon and Sha-Tin, including Sha-Tin section, Eagle's Nest Tunnel, and Sha-Tin Heights Tunnel, has conducted a toll rationalization study, and we will be reporting to the Transport Panel in this year. And also the TD in the bus route planning program in 2018-19, in preparing for the program, has made 7 improvement measures, and we're now consulting the relevant district councils. Now, in monitoring the operation of the operator of Changsha control area, the TD has set up a relevant group together with government departments to help improve the work of the relevant operator. And the In response to the Audit Commission's report, we have proposed a number of measures, including specifying the role and functions of the GMT, closely monitoring the operators' performance, and also making sure that the manpower level is strictly adhered to.
In 2019, when the contract is to be renewed, the Transport Department will also check the clauses and specify manpower requirements, and there will also be provisions for calculation of liquidating damages. I'd like to thank the Director of Audit and also his colleagues for conducting a professional, independent, value-for-money study. The THB and the departments concerned agreed with the content of the report and accept the recommendations of the report. The THB will, on the policy level, provide suitable guidelines and supervision to the various departments and monitor the progress and implementation of various improvement measures, ensure that all the recommendations are effectively and completely implemented with a view to further improving the usage rate and raising the management of Route 8 Sha-Tin section and also the quality of contract management of future contracts. With regard to the details of the construction contract of Sha-Tin section of Route 8, specific traffic management measures and day-to-day management issues, the department heads and colleagues present are willing to answer your questions. Thank you. Thank you, Director. Thank you, Secretary. Before we open the floor, is any member who would like to declare interest? If not, then I open the floor to members. Mr. Lam Cheuk Ting is the colleague leading the questioning. Mr. Lam, please.
Yeah.
Now, we had a closed-door meeting. In these 4 hours, it will be unlikely for us to complete the open hearing, public hearing of this report, but we will not start part 4. Therefore, those colleagues who are responsible for part 4 may now leave until the next public hearing. Part 4 is related to the RHSD, EMSD, and TD. If you want to stay and listen to our questions and also the answer to the Secretary, you may remain. Otherwise, you may be excused and go back to your office and do your work. Mr. Secretary, if you, it's up to you to decide who will stay. We don't want to waste your time. We don't want to hold those colleagues up, in particular those who are to answer part 4 of the questions. Okay. Those responsible for part 4 have left. Thank you very much. Mr. Secretary, we will have one more public hearing on part 4. We will just deal with part 1, 2, and 3 today. Yes, Mr. Lam Cheuk Ting. Yes, thank you, Chairman. First of all, I'd like to thank the Audit Department for Audit Commission for drawing up the report. And just now, the Director has highlighted the important points of the report. I will first ask part 2, point blank. Part 2 deals with the Sha-Tin section of Route 8. That is a 1.4 kilometer long viaduct from Lai Wan to Butterfly Valley, and there is also a segregated carriageway and also noise barrier and noise cover, and also management of Contract A. These will be covered by my questions. According to the report, Contractor A got the report, and then supervision by Consultant X, and it is found and that the project was delayed by 24 months. 276 days were granted for EOT due to inclement weather. 463 days were delays, resulting in liquidated damages. There were disputes, and according to the report, in draft there were problems in drafting the contract, and there were some mistakes in the estimates, and therefore the project was delayed by a year or so. The government had to pay about $270 million to the contractor, and at the same time, the government received $130 million from consultant X, and therefore the government lost $140 million. Is my understanding correct? The loss is $140 million. These are numbers. The Secretary. Mr. With regard to the numbers mentioned by Mr. Lam, he may say so. Now, your point was also mentioned in the Director of Audit report. And basing on the original requirement, the correct implementation arrangements, the tender price would go up, so the number might not be $140 million. I will go into this detail later. But on paper, the government had to pay $140 million more. My question is on paragraph 2.5. Right. Let me say briefly on this. Maybe I ask the Secretary to explain simply to the public how did this dispute come about. Paragraph 2.5. Now I talk to my colleagues with regard to the contract disputes. There were two items. The construction of the viaduct and also the design, and also the quantity estimation and the pricing valuation, and the valuation were different, and also whether the loading was also considered, so on and so forth. They were all in the report. Chairman, to put it simply, with regard to the structure of the viaduct and also the design of the viaduct might not be adequate, and therefore in doing the works, the contractor said that it would not be feasible according to the original design. Therefore, additional money would be needed by using other means of conducting the works, and also the cost for that was also disputable. The contractors asked for more, and you said that that wouldn't need so much money. Now, in paragraph 5, it is said that contractor A submitted claims under contract A, of which consultant X certified a much lower sum. What was the original amount of claims? The Secretary. I asked the Highways Department colleague to answer the question. Director of Highways. Thank you, Chairman. Contractor A originally submitted a claim of $1 billion. Wow. He asked for $1 billion, but consultant X, what was consultant X's suggestion or assessment? Consultant X assessment on the amount. Chairman, as for this situation, the consultant has raised a number of, or rather, they raised a number of claims. The consultant looked into that and approved a certain amount. But contractor A didn't agree. He asked for $1 billion. Contractor A asked for a bigger sum. As for this $1 billion, the consultant didn't give a number. Consultant X approved how much? Director of Highways. The total approval, I refer to the claims. You said that he approved a certain amount of claims. Originally, there were a large number of claims, and then he approved a number or an amount, and then contractor A was disagreed. Yes, I've heard that. Yeah, I've heard that. My question is, now he approved an amount to be paid to contractor A. What was the amount approved? Please wait until I ask you to reply. If you ask and answer directly, it would be difficult for other people to understand. Many are watching this public hearing. Mr. Lam, maybe you give him some time. After he has finished replying, you can stop for a while. The Director of Highways. With regard to the claims, previously, the consultant certified $85 million of claims. Now he certified that amount less than 10% of the claim, because the claim amounted to $1 billion. And there was no agreement, and mediation started in March 2009, and there was no satisfactory outcome. Therefore, contractor A asked for settlement, or rather arbitration, and the arbitration notice was served on the administration. And the government engaged a quantum expert to assess the claims and assist in the arbitration, and also an engineering expert to review consultant X's design for the viaduct. In 2008, the administration knew there were claims made by contractor A. Shouldn't you engage a quantum expert and an engineering expert earlier to assess the grounds for the claims, so that you know whether you were in the wrong or not, or you only wait after they ask for arbitration? In dealing with claims, there are different ways. Getting or engaging a quantum expert generally will be done at the arbitration stage. Before that, there is mediation. In the mediation process, we reviewed the situation internally and consider the amounts that we should pay. We did some preparatory work. Mr. Lam, Chairman. With regard to mediation, with contractor A, what was the expenditure on mediation? Director of Highways. Director of Highways. Well, if you are not able to provide some numbers, then please explain to us. Explain to us why you are not able to answer the question, or maybe because of mediation or arbitration, you may not be able to disclose the data. You should also explain to the public what is mediation and what is arbitration, and also why mediation is to no avail and arbitration is necessary. And in fact, the numbers are public information. But if you have difficulties, please tell us. We are trying to find the facts. Chairman, let the public understand what is meant by mediation and arbitration. Mediation is a simple and direct method. Now the client and the contractor ask an arbitrator to assist both parties in the discussion to achieving an agreement. It is not legally binding. But if mediation is not successful, according to the clauses in the contract, both parties, including the contractor of course, can go down the route of arbitration to reach a settlement on the disputes arising from the contract. The outcome of arbitration is legally binding. Both parties are working under a process similar to that of the court in settling the dispute. As for the expenditure on mediation, I think the information is rather sensitive, and therefore it is not appropriate for us to mention the number. Chairman, you say sensitive. Does it mean that you have a contractual arrangement with the mediator so that you cannot disclose the expenditure? In the mediation process, there is a lot of information which is privileged. And because of this, such sensitive information cannot be disclosed. Now, we are counselors. We do ask questions. If you are not able to answer the questions, please explain to us, and that will be all right. With regard to mediation, how much you spend on mediation, can you tell us? If not, then explain why you cannot tell us. Mediation. Just now, I've already said that mediation, the expenditure on mediation is sensitive. It is sensitive because in the future, in other cases, in relation to other cases, there may be, there will certainly be impacts. When the public, including parties which we have similar disputes, when they are aware of the expenditure in this regard, that will be unfavorable to our side.
right, then I would like to move on to paragraph 2.9. So 273 million is the settlement sum, inclusive of interest and cost. So can you tell us what the interest is? That shouldn't be sensitive information. Thank you, Chairman. Well, we have already disclosed all figures possible. We have already told the Audit Commission about the figures we can disclose. The other figures that we didn't disclose are sensitive information. Chairman, well, I don't quite understand this because for arbitration, I understand that it involves a third party and therefore it would be a bit more sensitive. But for this settlement, there is a sum inclusive of interest and cost. I try to understand your interest because it is public money. Can you give me an answer? Director of Highways, you can go back and take a look at the figure because the actual sum here states 273 million. Well, you can let us know how this number was reached and tell us how much of it was actually interest and cost. Because you already have a general number here. Thank you, Chairman. I have already mentioned earlier that the breakdown of figures is sensitive information. If we disclose these figures, we need to seek legal advice before doing so. Thank you, Chairman. All right, I'll wait for your legal advice. Let me ask you another number to see if that is also sensitive. Under para 2.9 bracket C, which is page 17 in the Chinese version, it said that the Highways Department considered that the proposed settlement would cost appreciably less and be beneficial to the government having regard to the assessed total risk exposure mentioned in B above and the costs in continuing the arbitration proceedings. So, 2.73 million is already quite beneficial to the government to conduct arbitration. So what was the proposed settlement figure? Could you tell us the number? Well, I asked Director to explain mediation and arbitration because arbitration is legally binding and should be kept confidential. So it is not one-sided. Much of the information is to be kept confidential. Members can ask questions. They can try to explain it without going into details. That's why I told you to explain what the arbitration was, because you know which information you could give. It involves both parties and therefore it must be made in the agreement of both parties. Well, Chairman, I understand, but I need to ask, because if you're not able to give us an answer, you have to let the public know. Otherwise, the public can only read the report and then listen to our questions, yet find that we are not getting any answers out of the questions. We give you opportunity to explain. Director. Well, thank you, Mr. Lam, for your question. The figure you asked for is very sensitive. As it involves strategy behind the arbitration. Disclosing such information will have an impact off on future arbitrations. Therefore, if we are to disclose such information, we need to first seek legal advice. As the chairman has said, any information related to the arbitration is legally binding and should be kept confidential. Thank you, Chairman. Well, I'm not asking you for a response here, but please do take a look at the interest. I would like to know what the interest is. All right. I'd like to now refer to the responsibility of the consultant. In paragraph 2.16, the engineering expert said that the construction and erection loadings did not appear to have been properly considered in the design. Second, the contract drawings only showed the use of balanced cantilever method of construction but did not indicate the need for certain requisite construction systems, which is the substantial propping systems and cranes. And thirdly, consultant X response to a tender query requesting clarification of the temporary loads used in the design could lead to confusion that construction and erection loadings had been considered in consultant X design. Just by looking at this, it seems that consultant X did not do his job properly. Well, yes, if you put it this way, the consultant had a responsibility. Therefore, we made claims which was 133 million. Other than the 133 million in claims, were there any other penalties? There were inadequacies leading to government losses. Therefore, we made claims against consultant X. We assess the consultant's performance. Which will be reflected in our assessment and review. Would there be any impact on future tenders? For example, prohibiting the consultant to make tenders in the next few months or next 3 years. Would you also consider that in your selection for future projects? Thank you, Chairman. We do look at past records of consultants' performances. Therefore, if a certain consultant did not perform well, they would have a lower grade, which could affect their success rate in getting new contracts. Mr. Lam, it seems that there is no prohibition arrangement in tenders. Well, so it has brought losses to the government by 133 million and led to delay in commissioning of the viaduct. Why didn't you penalize the consultant by not accepting their tenders within 1 year or a year and a half? Thank you. we do have our own system in managing consultants. Based on this system, we manage the consultants and we would assess it based on our own procedures. The consultant's performance is reflected in the report. Director, why don't you put it this way? You penalize a consultant 133 million, but then there is a without admission of liability clause in the contract. So you have to tell Mr. Lam that yes, a settlement was reached, but there was no admission of liability. Therefore, you cannot add on other penalties. Thank you, Chairman, for your reminder. When we try to resolve this with the consultant, we asked for compensation, and during the process, I can say it was made on the basis of without admission of liability. Therefore, under these circumstances, we cannot further penalize the consultant. Thank you, Chairman. But you did review the performance and responsibility. You can actually try to take away points, right? Yes, I did mention earlier that the overall performance would be reflected in the quarterly report. Mr. Lam, thank you. I understand. So if the contractor is at fault and it compensates the government, then it would be made on the basis of without admission of liability, and the government cannot further penalize the contractor. Except putting it in the point system on record. Am I correct, Director? Our Secretary. Thank you, Mr. Lam, for your question. The consultant X should pay for the losses. We did seek legal advice, and we find that contractor A made claims because the work done was not included in the contract, and therefore contractor A was only asking for what to be paid for what they did. Even for the 200 million compensation to contractor A, the legal advice said that the blame should not be put all on consultant X. And even if there was negligence in the contract, if we could look at the tender, then you could see that the tender price would actually be higher. So we considered all the many different aspects, and we believed that this arrangement is appropriate. Thank you. Mr. Lam, perhaps I could ask the legal advisor to tell us about the clauses in the thank you. There's a contract on profitable income. So when the court needs to interpret the contract clause, as it did not appear consistent, the interpretation made by the court usually is not beneficial to the drafting side, because the court would usually protect the passive recipient of the contract. So if there were any unclarities in the contract clause, then it would usually not be beneficial to the government side. All right, thank you. Well, in 2.18, you could see that under bracket A that the legal opinion was not all the disputes with contractor A could be attributed to consultant X. I don't understand why, because contractor A worked on the design. So if not all of the disputes are attributed to consultant X, then how do you explain it? Director. We consider the overall claims or claims over 1 billion. A part of it is related to the design. The 270 million is inclusive of all claims. So this is not only a design issue. Thank you. All right. May I refer you to 2.22? No, how? Okay, Albert, after this question, you let Mr. Shiu also ask his questions. All right. Paragraph 2.22. Audit noted that consultant X's response to the tender query could lead to confusion and could give rise to grounds for claims on the design for viaduct structure and erection from contractor A. So there are 3 points here. A, it was consultant X contractual duties under consultancy X to answer queries on the tender documents. B, based on Highway Department records, consultant X had forwarded the tender query to the Highways Department for information and copied the response to the tender query to the Highways Department when issued. And C, there was no record indicating that consultant X had sought the Highway Department's comments on the response to the tender query before issue. Chairman, can the Highways Department answer us that when they receive a tender query, does the Highways Department bear the responsibility to check whether the consultant's response is accurate? Director. Thank you, Chairman. Well, according to our requirements, we do not have the responsibility to verify the information. When we hire the contractor or the consultant, we have already given this responsibility to the consultant. Mr. Lam, that means you're just keeping all the communication for record purposes only, since you do not verify any of the information. Am I correct, Director? we would oversee the whole process. The consultant must respond to these queries within a reasonable period of time and to copy the response to the tenderers.
This is to ensure that the tenderers are on a fair or level playing field. So the same information is provided to all tenderers. Mr. Lam, I am astonished. You are outsourcing your responsibility to the consultant, and the consultant has given you a copy of the tender query and their response, and obviously there is a problem with the response, and you're telling us that you are not responsible for that response. Your only responsibility is that the consultant will reply the tender query in good time. How can the government outsource your responsibility of monitoring this kind of issue to the consultant? Now, Director and Secretary, after this incident, would you review your approach of monitoring the consultant and the government's responsibility? And you should not let the consultant make a wrong response and leading to a loss in government money, and then you have not recovered all the cost from the consultant. We are losing over $100 million in public money. How can you be answerable to the public? Director, based on this experience, in the future, we will ask consultants if they respond to tender query, they should abide by the tender documents, and they should adopt a stringent approach. If the tender query is related to certain changes in the tender documents, then it should notify the Highways Department. So that, well, they are already doing that. Well, before they make a response, they should notify us. In the Secretary's speaking notes, a number of proposals have been made as to how they will work in the future. So, Secretary, can you respond? Because in your speaking notes, you have already made some proposals. Can you repeat those? Thank you, Chairman. Thank you, Mr. Lam. Well, you have pointed out the problem. In 2.23 of the audit report, it sets clearly that there are inadequacies in the arrangement then. For example, there is no further guidance for handling tender queries, including the need to provide a clear and accurate response. And we hope that the consultant, before making the response, consult the relevant departments. So we accept this proposal. We have also asked the relevant departments to review the work guidelines. So we hope to implement the recommendations in the audit report. I have no further question. I think you asked a very good question. We should be forward-looking. Apart from contracts related to roads, there are also contracts for railways, etc. We should do the same. We should be forward-looking. Well, at the end of the day, it is public money which is at stake, and the government is obliged to take a look at the communication between the tenderers and the consultant, and you should interfere when there is a problem. Now, Mr. Xiu, you are talking about charting section of Writ 8 for contracts A, B, and C. These are the contracts under Route 8. Is that right, Director? There is a section, Sha Tin section of Route 8, contracts A, B, and C, and to a certain extent contract D are involved. And contract D covers other sections of Route 8 as well. Thank you. Now for contracts A, B, and C, are they separate contracts setting out or covering different projects, or are these projects taken forward at the same time, Director? Well, the contracts should be implemented one after another. Well, the project was sizable in scale, and we have broken the project down into 3 contracts. And taking forward the projects, actually, they were taken forward at the same time. Mr. Peter Shiu, well, if they were taken forward simultaneously, why are you breaking them up into 3 contracts and not include them in 1 contract? Director, for big works projects, usually we consider this. If we just have 1 contract for a big project, then only a few large contractors could undertake the work. So that's not good, for competition's sake. If only few tenderers came forward, there was less competition, and very often the tender prices would go up. So that's number 1. And also, if we just have 1 contract, the risk would also go up. Mr. Shiu? Well, if that is the case, how come that consultant X won the 2 contracts and not, say, consultant XYZ got the different consultancy contracts? Well, there is a difference between construction contract and consultancy contract, and the latter includes also the design. And for big projects, we have to have an integrated design. Of course, there will be exceptional circumstances warranting different approaches, but usually for 1 project, we will engage 1 consultant. And this time round is also a bit special. For contract C, we engaged a different consultant company, because in Sha Tin, the CEDD had engaged a consultant to do the relevant works. So because of that contract, we had entrusted the CEDD to help take forward that. Mr. Peter Shiu. Well, you mentioned, Director, about an integrated design. Why was it the design not undertaken by 1 consultant? And then later you could break up the construction contract into 3. Then that would be in line with your principle. Maybe you should have just 1 consultant working on an integrated design. Why wasn't that the case? Director, as I said, for a large-scale project, we would like to have 1 consultant undertaking all the design work and supervision of the construction. But in exceptional circumstances, after taking into account a number of factors, different consultancy contracts might be drawn up. Now, usually, say, in this case, the CEDD at certain locations was already taking forward some projects, and it, to a certain degree, duplicates with the big project, and maybe there are other considerations. So under that circumstance, we would be entrusting part of the work to the CEDD. And in that case, a different consultant will be responsible for that part of the work. Mr. Peter Shiu, in Hong Kong, how many qualified consultancy firms are there in Hong Kong? And for this project, is it an invited tender approach or an open tender approach? Director, in Hong Kong, there are many consultant firms which can take up such work. In engaging a consultant firm, we go through certain procedures. Basically, there is a list kept by the CEDD, and we will take a look at the list to see which consultant firms will meet with the requirements of the consultancy contract, and then we would invite the relevant consultant firms to put in the bids. Mr. Peter Shiu, 1.01 paragraph in page 8. Now we should have allocated $7.08 billion. The government has ultimately used $6 billion or so, 87%. Well, is it a normal case where the allocation will not be fully expended? Director, for works projects, we would normally complete the project within budget or the allocation. But for some projects, there is a cost overrun, and in that case, we'll have to come back to the FC to apply for supplementary funding. Well, but that kind of project is small in number. Now, Mr. Shiu, we were discussing the consultant X and consultant Y and the problems in relation to contracts A, B, and C, and they've not been doing a proper job. Now, going by the government's established procedures, now normally the consultant will come up with a design and hand over the design to you. And will there be professionals within the government departments to assess whether their designs are reasonable? Director, we have a professional team to manage these projects. In terms of the overall management, we would assess whether their design is reasonable, overall speaking. But when it comes to the details, we would require the consultant to have an independent professional team on the significant parts of the project, and then a certificate has to be submitted to us. Mr. Shiu, for consultant X and consultant Y, for the project, they would receive a consultancy fee. Can you tell us the consultancy fee? Thank you, Chairman. Well, the consultancy fee was arrived at after a tendering exercise. For consultant X, is $83.5 million. And for Y, it's $57.6 million. So consultant X has received $83 million or so from the government. Director. Thank you, Chairman. That was the sum when we awarded the consultancy contract. Mr. Xiu, Mr. Lam Chak-ting has asked this before. For the contractors in contracts A and B, they've been trying to claim an amount of close to $1 billion from the government, and after negotiations, it has been cut down to $273 million, and the government is responsible for $140 million, and the consultants have paid the government $133 million. So the consultant has to, dig into his own pockets to the tune of some $50 million, right? Yes, that's correct. Mr. Lam Chak-ting has asked about paragraph 2.18 of the report. The Highways Department has said that not all of the disputes could be attributed to consultant X, and the government has to be responsible for $139 million. In the last session, we said that the contractor would like to claim an amount of close to $1 billion from the government. What are the major items under this $1 billion amount? Oh, you don't have to give me the small items. What are the major items covered under this $1 billion claim amount? Director. There are different classes of items, and that is alterations and variations items. They are asking for $580 million, and measurements is $50 million, and prolongation costs is $120 million, and other expenditure is $200 million, and that adds up to a total of $1 billion. Mr. Xiu, variations. What do you mean by variations works? Director, when we take forward major projects, during the course of doing so, we have to make variations based on the actual conditions of the sites. The consultant will make such variations, orders, and ask the contractors to work on them. No. And for alterations, maybe we need to do extra work during the course of constructions. So in taking forward projects, and this is very a common thing. And this time, the contractor is asking for an extra $580 million. So, Director, you can explain to the member that this contract is a special one, in that it is by measurement, and that the amount to be charged based on the actual measurement, and you can try to explain that. And there is a tripartite approach involving the consultant, government, and the contractor, and that the contractor will follow the orders made by consultant X, and if there is a variation order, then that has to be followed. And you try to explain how this happens so that members can understand more. So can you explain why there is a situation of a variational order needed? Please explain in detail. Director, well, let me try to use an example to explain the variation order concept, and also additional works. Say at Butterfly Valley, there was a slope. And when the consultant did the design, it conducted some some ground investigation, but in the actual construction work, we found that the rock conditions were found to be different from that discovered during the ground investigation work. So as a result, further slope stabilization work is needed, and more soil nails were added.
And when we execute the projects, if the actual situation is different from the information we have obtained, then this consultant will have to give directions to the contractor on changing certain works arrangements, and more works will have to be done. And therefore, we need to pay more to the contractor because the contractor has done more. Mrs. Hill, concerning the Butterfly Valley situation, you did the investigation, and later the situation was different from the investigation outcome, and you add more soil nails. Is it regarded as a variation? A VO is variation order. When we make a change, then the consultant will issue a variation order. These are VO. VO means variation. What about additional works? It's not additional work. It's a VO. Is it? Or isn't it? As for VO, variation order has various types. A consultant gives direction to the contractor to do something which is not written clearly in the contract, and the contractor is asked to do something different, whether it was not mentioned originally or whether it was mentioned but more had to be done, then these are variations. Now, Mrs. Hill, now you referred to variation works, $500 million. So variation is VO. Then what about additional works? The director. Just now I explained. Variation order is this. Variation or addition. That means a change. It's the nature of the change. Variation order is an instruction. Whether it is a change or variation or whether it's additional. They are all included in a variation order. Mr. Xu. So variation is just the same as additional. Variation order includes additional and variation works. Variation means that if it is not in the contract and because of the actual situation, more work is to be done, you can call it additional, you can call it variation, and you have to pay. Anyways, it's rather complicated. Contracts are rather complicated, and we need to understand it very carefully. We don't want to make mistakes. And therefore, you need to explain with patience. We're not in, members are not in the business. You need to explain to them so that they can understand. Mrs. Hill, do you understand? Now, Chairman, can I understand it this way? Now, in the design of the consultant, they have not taken into account the variation or additional works. And if you are going to do this, then you have to issue a VO. Now, when you come to the site, you find that you need to add more soil nails. That's variation. And as for additional work, that is not included in the original design. Unexpected. Now, as for additional work, it means that when you go to the site and you found something which is not already included in your design. Well, in fact, if it is not estimated or expected, then there will be variations. It is not included in the contract or specified in the contract. But when it comes to actual execution of the works, some changes have to be made, and we call it variation. In 2.18, the Highways Department said that it might not be entirely the responsibility of Consultant X. The chairman does explain that when you come to the site, you discover that you need to put in more soil nails. In paragraph B, the government has to pay $140 million in addition, because in the original design that stuff was not included. If it had been included, you still have to pay for that anyways. If it had been included in the contract, you still have to pay it anyways. Well, it is hard to come to this number. $270 million was an agreement with the contractor. If it was not $273 million, then that may include lawyers' fees and other claims, and that may be even more. In fact, this is an agreement or settlement with the contractor, and the $133 million is a settlement with the Consultant X. The consultant made a mistake, not entirely because of his own fault, and we agreed that the amount was $1.33 million. And the two numbers worked together, and so the balance is $140 million. It's 273 minus 133 is 140. But the two numbers are different. But if you look at the total, the entire balance, then is was $140 million. It's not the $140 million is not the absolute figure. Thank you, Chairman. It's just like working with teaching computer. The one who teaches understands it, but the one who listens may not understand it. $270 million and $130 million are two separate numbers. $270 million, as I explained earlier, was resulting from the claims. The contractor asked for or claimed $1 billion. And there were different categories under the claims. Some were related to the design of the consultant. Some were not. We came to a consensus that the government paid contractor A $273 million because of various reasons. We consulted the legal advisor, we consulted various experts, and they came to the conclusion that that was the risk borne by the government, and also the cost of arbitration. And the total would be substantially bigger than $273 million. Consider the whole. If we could pay, considering the whole, if we could pay $273 million, that would be favorable to the government. That's considering the whole picture. As for the consultants, or as for the consultant, we were of the view that the work by the consultant was inadequate, leading to loss incurred by the government, and therefore we recovered the loss. We recovered the loss from the contractor. Our legal advisor assessed the amount, and that consideration also included the costs of arbitration. Finally, the number was $1.33 million. If we accepted that compensation, that would be favorable to the government on the whole. $270 million and $130 million were arrived at through these processes. They were not out of the same problems. So if you might subtract one from another, might not be appropriate. Thank you for the explanation. Chairman, I did not look at your contract. Generally speaking, either the contract is according to measurement, you do that much, and therefore you are paid that much, including the materials. As for unforeseen matters, you don't want to foot the bill. You just take up the site and then you do the work by measurement, or you take the risk and you underwrite the total cost of the contract. It's a matter of bearing risks. If the cave-in is smaller, then the contractor will have a windfall. But if the cave-in is very deep, then the contractor may go bankrupt. So in constructing viaducts, and I don't know whether you do it by measurement. Maybe I ask the director to answer your question. That's a good question. I think, Director, can you explain whether it's a measurement contract so that the member can understand? Yes, thank you, Chairman. There are two types of contracts. One is a lump sum contract. We know the quantity and the uncertainty is low, and then we will award a lump sum contract. As for this contract, it is a contract by measurement. When there is a lot of foundation, when there is a lot of foundation works, or when there are many factors which are not clearly within our grasp, then we will adopt a measurement approach. Chairman, Mr. Siu, now would you please try to help? Kenneth will have a meeting starting from a quarter to 11. Yes, this is my last question. If it is a contract by measurement, how can there be any claim at all? Well, that's my question. I will ask it later. You can claim VEO lawfully. How can there be any argument? It was based on original design, but it goes beyond the original design. Then that's the problem of the design. Kenneth, you and Paul will have to go to another meeting at a quarter to 11. Yes, you have a subcommittee meeting till at 10. So, Kenneth, Mrs. Hill, my apologies. You can follow up later, afterwards. Well, I want to ask questions on contract management, and they are general questions. Well, if I describe Route 8 is made up of A, B, C, D contracts and two consulting contracts, X and Y, is my description correct? The director. Yes, that's correct. Okay. And then my further question is, construction contracts, A, B, C, D, and engineering support contracts, are they all tripartite contracts? Yeah, correct. With contract consultants X and Y, you have two different contracts, and they are bipartite contracts. Are they? Aren't they? Let me explain a little bit here. The contract is a bipartite contract, but one contract is the highway, belong to the highways, and another contract belong to the CEDD. A, B, and D were highways contracts. C and consultant Y contract were CEDD contracts. Okay. Good. I want to know the ownership. The highways and the CEDD are involved. Are they ultimately answerable to the THB? Which bureau is responsible finally? The Secretary. If you look at the overall Route 8 Shatin section, they were divided it was divided into 4 contracts. They were viaducts and tunnels, BC tunnels, and D traffic management and control system. This is a THA project, a THB project, and therefore I'm here. Thank you. This is such a large-scale infrastructural project. In drawing up the consultant's contract or construction contract, there should be an established procedure. Can anyone tell me, in drawing up such contracts, what is the workflow? Your consultancy contract may be different from your construction contract. If there is a flow chart, can that be given to the committee? Who makes the proposal? And will you get an outside lawyer? I know that some construction contracts were drawn up by outside lawyers. And when did the DOJ get involved? The Director. Thank you, Chairman. Before the meeting, we submitted some information papers, and within these papers, reference was made to the workflow. Gen 2. Yes, please go on. Director. It's in Gen 2. Please go on. Explain. Those who are listening into our hearing may not know. Can you explain Gen 2 then?
Well,
my colleague will explain in detail. Mr. Low, are you Mr. Low? Yes, Kevin. To put it simply, the consultant will look at various parts of the tender documents, the drawings, and so on and so forth. Now the member asks you the workflow, the procedures. Perhaps you start with the consultancy contract. The consultant helps you to look into many things. Who issued the tender, how is the tender issued, so on and so forth. Please explain so that we can have a better understanding of the matter. First, the consultancy contract. With regard to consultant X, our own colleagues drew up the tender document, or the contract document rather. When there is a draft, then we circulate the draft among members, because each project involves many members. We circulate paper among members and they among departments, and they will add comments whether there should be additions and deletions, and whether the scope will be expanded or reduced. And after that, then we therefore log in the document, and then we issue the tender invitation. Did the Highways Department look into that? Usually, for consultancy contracts, we didn't ask the DOJ to vet those contracts. Do you have internal lawyers? In-house lawyers? Now you have engineering experts. Don't you have? Do you have legal experts? You have to answer that carefully. You have tender procedure, and there is a central tender board, and in the central tender board, you have legal advisors from the DOJ.
所以你去答咧，唔好就咁順口開河去答。
So you have to think very carefully before you give an answer, because you do have your procedures. Because members know the answers, but they allow you to explain. And if you give the wrong answers, or it's not then very good for us to have to point out your inaccuracies. All right, thank you. You asked a question on contract and consultancy. For contract over 300 million, then we will need to seek legal opinion. Let us go back first to the consultant contract. Then we would invite tenders, and then we would assess the tenders, and then we would return it to the CEDD, because they have the director of the CEDD in charge of a committee to vet the tenders. However, the contracts are different. The contracts will be based on the needs of the art projects, on the design, on the bills of quantities, etc. Well, of course, they would need to then give this back to our department. We do have someone in the department to be responsible for the contractual issues. After reviewing the contractual issues, then there would be comments given on whether some things could be cleared up in the contracts. For larger contracts over 300 million, then the legal department must be consulted. And so then after they review it, they would give us back their views and comments. And only by then would we invite tenders. Then we would assess the contracts, and then would hand it over to the FSTB. To vet and to approve it. All right, Kenneth, I only have a couple of minutes. So I want to ask whether the mediation and arbitration processes are boilerplate, that you would have a standard mechanism for both arbitration and mediation. Director, yes. These are our standard clauses. So these are your standards, that you would not bring this to court as long as you have mediation and arbitration. Director, yes, the chairman has raised this point before. Arbitration is much like court. Therefore, we use arbitration as the ultimate resolution for contract issues. All right, thank you. All right, I am going to another meeting now. Well, both of you need to go. How about we take a break for 15 minutes, because we do not have a quorum. Paul, you also need to go over to the other meeting, right? Yes. Well, your meeting starts at 10:45, right? Let's take a 15-minute break.